Everyone, my name is Jade. Tyrrell. I'm an associate here at Carrol and O'Day Lawyers. Carrol and O'Day, for those of you who don't know, has a 120-year-long history of providing robust advocacy and high-quality advice to its clients, which include individuals to large and small corporations, unions and charitable organisations. The firm covers a number of areas of law across our services for personal, business, community and associations and compensation. And on a personal note, I found during my time here at the firm that the firm itself and my colleagues always strive for access to justice, for accountability and for fairness, which I suspect are some of the themes that we might hear a bit more about this evening. And essentially, Carrol and O'Day has a long-standing history of continuing involvement in the union and not-for-profit sectors. So we're very happy to have you here this evening, and I hope you enjoy the night. Thank you so much.
My name is Lewis Hamilton and I'm the President of the New South Wales Society of Labour Lawyers. It's my pleasure to welcome you here this evening. Before I do, I just wanted to firstly pay my respects to the Gadigal people of the Eora Nation and to their elders past, present and emerging. I also thank our sponsors, Carrol and O'Day, for generously allowing us to use their venue this evening. Before we move into the substance of tonight's proceeding and before I pass you over to our excellent panel of speakers, I wanted to just give you a taste of what our society is all about. We are the meeting ground for progressive people involved in the law who believe in labour principles of fairness, social justice and community. We're for those that believe that law and politics are inseparable, and our members are drawn from many facets of the profession, but we have one unifying connection. And that is that we believe that the law must be about people in the way that it is formed, interpreted and applied. With that goal in mind, we hold events and opportunities for our members, and we advocate to have the voice of our members heard within Australia's oldest political party, but also more broadly within the legal profession. We remain institutionally separate from the Australian Labor Party, but we nonetheless share its principles, and we aim to shape its approach to the law for the better. And that leads me to this event. This event arose because the political class, but in particular the Labor Party, realised that the law and the financial institutions that operated within it, and dare I say sometimes outside of it, were failing people. A Royal Commission was formed which throughout 2018 heard from casts of individuals who told a story of a financial system that had very much left them behind. And that Royal Commission handed down its findings in February. And now we find ourselves where we are today, on the cusp of a changing financial landscape. And this evening our society is very pleased to bring you a panel who will assess this changing landscape. A panel of advocates and academics who know the ins and outs of this changing universe. Our panel tonight will be moderated by Elliot, a barrister at 5 Wentworth Chambers. And I'd like to now pass over to Elliot, who will introduce our cast of speakers. And I look forward to some insightful debate. So please join me in welcoming our panel. Thank you.
Thank you, Lewis, and good evening, ladies and gentlemen. My name is Elliot Olivia, and it's my pleasure to be your moderator this evening. On the 1st of February, following much speculation, Commissioner Hayne delivered his final report into misconduct in the banking, superannuation and financial services industry. So now, 2 months on, after the dust has settled, what has been the real impact of the Hayne Royal Commission report on regulation and enforcement in the financial services sector in Australia, and what changes are yet to come? To discuss these issues, I'm very pleased to be joined this evening by our panel of experts. Dimity Kingsford-Smith is a Professor of Risk and Regulation at UNSW Law School, where she teaches and researches on theories of regulation, financial regulation and corporate governance. She also holds the position of Director of the school's Centre of Law, Markets and Regulation. Dimity has also served on a variety of policy-making bodies, including as a member of the expert group assisting APRA with its review of enforcement policy. I understand that's been delivered but not made public yet. And previously as the independent consumer advocate to the National Australia Bank. Dominique Hogan-Doran is Senior Counsel at 5 Wentworth Chambers, specialising in corporate and commercial regulatory investigations and public inquiries. She also acted in the Hayne Royal Commission, I believe CBA, Aussie Energy. Dominique is a leader of the Commercial Bar, and is recognised by Doyle's Guide and was named Barrister of the Year in the 2016 Australian Law Awards. Miranda Nagy is principal lawyer at Maurice Blackburn in the firm's class action department, where she is leading 2 major consumer class actions, including one of the recently settled cash converters class actions. Miranda has also led and been involved in several securities class actions and class actions involving managed investment schemes. So we're going to run this evening first. I'm going to ask Dimity to come and give us an initial overview of the Hayne report, its findings and recommendations, before we jump into a panel discussion about some of the more grittier issues. It's going to be an interactive evening. I'll give you the opportunity to ask questions, so get them ready. I'll give it a go.
Well, thank you very much to Jade, Lewis and Elliot, and I'm very pleased to be here. And it's my role to talk to you a little bit about some of the cross-cutting themes of the Hayne report. It would take us way too long to trace through all the different subject matter areas or financial functions that the 6 phases of the Commission covered. So I'm going to try and elevate for you matters that appeared in all of those phases and on which the report turned in almost all of the recommendations one way or another. And then when we talk later, we can talk more about some of the practical details, some of the legal details, and as Dominique will outline for us, the great long list of consequential and anticipatory changes in the law that have happened in this area over the last year. So, my first cross-cutting theme is the importance of non-financial risks. Australian banks enjoy financial soundness and are recognised for being financially well managed. And one explanation for the widespread misconduct revealed at the Commission hearings is concentration on that financial risk. Non-financial risk has been downplayed and has affected customers. The losses that have occurred to customers, which we've seen at the hearings, is as a result of this unbalanced concentration on financial risk. Non-financial risk manifests itself in legal non-compliance, dishonest and misleading conduct, and unfair customer treatment. And the unfairness is seen in products and services which do not confer fair value or, in some cases, any value at all. It's also seen in denying, deferring and delaying customer dispute resolution and remediation. The prevalence of customer harm has led to loss of trust and large remediation payments. As seen in the wake of the GFC, non-financial risks can be monetised into financial risks, even existential ones. And less well noticed, non-financial risk, or less well noticed until the Commission, non-financial risk manifests in human cost, which has gained greater salience in public opinion, and I think is very important in considering what comes next. The second cross-cutting theme is culture, governance and remuneration. A cross-cutting principle of the report is that culture, governance and remuneration march together, as Hayne vividly put it. They reinforce each other for better or for worse. This makes the influence of remuneration, both variable and conflicted, central to the explanation of bank failings, but also a place to start with the improvement of conduct. Conflicted and variable remuneration is not limited to financial institutions. Hayne's observations have traction for Australian corporates more widely, from the executive suite to the shop floor, whatever kind of shop it is. Get remuneration right, Hayne argues, and much of governance, culture and conduct will follow. Boards and senior executives have primary responsibility for changes to remuneration, governance and culture to turn around non-financial risk failings at their organisations. And this too is relevant to non-financial companies and their leadership. The third cross-cutting point is about customer well-being, conflicts of interest and distribution networks. As well as governance and culture marching with remuneration, in Hayne's view, remuneration marches with conflicts of interest. The conflict between legal duties and self-interest is for Hayne always resolved in favour of self-interest. Conflicts are the immediate mechanism for misconduct and poor management of non-financial risks and consequent damage to customer well-being. These risks were most evident in extensive in distributor networks, aligned businesses of credit referral agents and in credit again, mortgage brokers, and in superannuation and wealth management, financial advisors, remunerated by commissions, whether upfront or trailing. Again, distribution networks of aligned businesses are hardly exclusive to the financial sector, and nor are volume-based or variable remuneration arrangements. Hayne's response was twofold. First, he recommended upfront fees in the pricing to be paid by consumers, and second, he recommended the same conduct standards should apply to all subsectors of the financial industry involved in the distribution of financial products and services to customers. And my final cross-cutting point before I concentrate on a couple of them to go a little deeper is apply, obey and enforce the law and regulation and make any changes that come from this report simply. The final report places a lot of weight on the application and enforcement of the law and regulation to meet the misconduct and failures of community expectations uncovered by the Commission. Hayne places responsibility for application of and obedience to the law by banks and bankers squarely on bank boards and senior management. We could expect the same approach to be taken in relation to other sectors. For example, at the Royal Commission into the aged care sector and the disability sector. Hayne places responsibility for enforcing the law on the regulators, APRA and ASIC. The latter in particular, being an enforcement regulator and not relying on suasion behind closed doors as prudential regulators do, is tasked by Hayne with public denunciation and court-based action. Cutting through the complexity of financial regulation, which complexity Hayne attributes to unjustified subsectoral pleading for special treatment, he identifies 6 normative principles from which all regulation in the sector can be understood. Obey the laws, do not mislead or deceive, act fairly, provide services that are fit for purpose, deliver services with skill and reasonable care, and when acting for another, act in their best interest. Understanding the purposes of financial regulation, so the intent of rules and what is expected, improves application, obedience and enforcement. And it also makes it easier for customers to understand their rights and to act on that understanding. Further changes to regulation should observe these 6 principles along with simplicity and connection to ethical purpose. Again, regulatory regime complexity affects other sectors, and a similar search for underlying purpose and principle, which is of course applicable to whatever that sector is, may assist with the compliance task as well as with customer care. So now I'll just have a few things to say about enforcement, and then secondly about the greater emphasis on ethical or normative decision making and conduct. The first point that we might make, and it's very obvious so I won't dwell on it, is the change in enforcement appetite at APRA and ASIC, most clearly projected at ASIC. And of course, the long list of consequential legislative amendments that are going hand in hand to increase the powers of investigation and enforcement, which goes with the increased enforcement appetite. There's also, and I don't think that it, again, is limited just to the financial sector, this change in enforcement appetite. It's a change which I think will be being registered at the ACCC and perhaps state trading, fair trading regulators as well. Secondly, there's a change in expectation of providers in the course of enforcement proceedings. ASIC's announced it will take enforcement decisions within 6 months of starting investigation, and this will require entities to respond to inquiries and investigations quickly. So there's already a tougher stance noticeable, and I think we can expect more of that. A change in the subjects of enforcement and the use of criminal law and higher penalties. This is also an important change of direction which comes from Hayne's report, and again it's particularly directed to boards and senior managers who he sees as responsible for values and culture, governance, compliance systems and conduct, and those are going to be the likely subject of enforcement. This is tied up with the banking executive accountability regime and the accountability maps that are flowing from that regime, and which will make it easier to identify which individuals are responsible and may have failed in discharging their accountability responsibilities. Let me turn now to a greater emphasis on ethical and normative decision-making and conduct. As already mentioned, Hayne argued for greater weight to be given to the 6 principles underlying financial regulation, and in particular he emphasises honesty and fairness. Fees for no service, perhaps the most notorious and systemic shortcoming the report reveals in both super and financial advising, is a departure from most of these underlying normative principles. The stark absence of fair value, or indeed any value at all, in fees for no service is a signal departure from the mutuality of bargain, which is important to the meaning of fairness in financial markets. If it's found that these fees were taken deliberately rather than as a result of system or human error, then dishonesty offences may be relevant. Misleading conduct may have occurred if banks misled customers about their rights or regulators about the facts of programs. The rationalising by bank executives and their advisors, including legal advisors, which led to fees for no service, involved technical contractual interpretation highly defensive of bank interests. This ignored the objects of Chapter 7 of the Corporations Act, the requirement to be efficient, honest and fair, which has recently become a civil penalty provision and which I'd be pleased to talk about further, and the underlying philosophy of fairness adopted by the Murray inquiry in 2014. To the extent that customers would and did complain about fees they paid for no service, the advice given about what customers were entitled to expect under ongoing service contracts also ignored the fact that the leading term of reference of the Financial Ombudsman Service, as it then was, included a requirement to determine disputes with practical informality, timeliness, and in a fair manner. Turning to courts and regulators now, and the ethical dimension further, there's beginning to be some evidence that in relation to financial consumers, it's not only Hayne advocating for an approach that elevates normative values. In the recent ASIC and Westpac decision of the Federal Court, the central argument was a highly technical one about the difference between general and personal advice, the regulatory consequences of which are significant and costly. Westpac's advisors, including its lawyers, developed a process which combined the known behavioural vulnerabilities of financial consumers with very technical interpretation of the definition of personal advice to offer search and rollover services. While the court did accept that Westpac was correct in one of the several technical elements of the personal advice definition, and that one element was enough, it also found Westpac to have breached the requirement to be efficient, honest and fair. This is a statutory standard imposed on all licensees which is beginning to take on the character of a paramount principle. It was the fairness norm which the court held to have been offended by Westpac's otherwise technically sufficient compliance. And as a final footnote to efficient, honest and fair, it was just in March past that this provision became a civil penalty provision, with the regulator's sanctions of financial penalties and disqualification as well as, of course, of the new relinquishment order possibilities that march with disqualification and pecuniary penalties now. So legislators are taking fairness pretty seriously too. And of course, these remarks in relation to Westpac are under financial services regulation, but there is, of course, fairness requirements in other regulatory regimes, and I don't think we can discount the effectiveness over time of the osmosis of ideas. Hayne's elevation of normative principles is not limited to fairness. Super trustees may find their too close related party connections with banks have resulted in dishonest behaviour under 1041G of the Corps Act. That involves criminal liability. And also receiving assent recently is a new definition of dishonesty for all the offences in the Corporations Act, which adopts the R.V. Peters principle that dishonesty is what ordinary people think dishonesty means. And as one wag put it to me, Dimity, this means that dishonesty will be tested by a jury of ordinary people, not a jury of bankers. And my final remark here is that, of course, Section 184, which is the criminal dimension of all the directors' duties, or the main directors' duties, which apply much, much, much more widely than just the financial sector, will be affected by this new definition of dishonesty. So thank you very much for letting me open, and I look forward to a conversation.
Thank you so much, Dimity. A report that emphasises fairness must be good for consumers, I suppose. Miranda, what's been the key recommendation coming out of the Commission from a consumer protection perspective?
Look, I think the first thing I'd probably say is that the recommendations, even though the Commission itself was a pretty spectacular and dramatic kind of series of hearings and events on the way through, the recommendations have not been quite as spectacular and dramatic, they've been quite measured. But I think I would probably say the idea that you have a sort of a single set of standards and it applies across, it applies to superannuation trustees and it applies to entities that handle insurance claims. I would say this kind of developing uniformity of standards and requiring everybody to behave in, an honest way is pretty important. I think, I guess on that sort of theme, the introduction of the civil penalty regime for breaches of super trustee obligations under the SIS Act, I think is pretty important. And I think as well the sort of recommendations that go to really recognising and preventing conflicts of interest are very important. So the recommendation that a super trustee cannot take on any other kind of obligation or duty other than being a super trustee, I think is very important as well, because there are all sorts of sort of quite incredible examples in the Royal Commission, such as where you had IOOF entities being superannuation trustees and responsible entities of managed investment schemes, and never sort of determining which capacity they were acting at any particular time and not recognising that there were conflicts by reason of that. So I think those sort of management of conflicts issues are really important. And I think insurance, why the recommendation that life insurance contracts be subject to an unfair contracts regime, that insurance claims handling will be, subject to the obligation to do this efficiently, honestly and fairly like any other financial service is very important. So I think those are really important consumer-focused recommendations that will, I think, change the behaviour of entities, in these really important parts of our economy and our financial system.
Dominique, and I should mention on your seats is a handout which Dominique has very kindly put together of all the legislative changes.
It was going to be a PowerPoint. It's actually going to be delivered as an exam.
Picking up on superannuation, that's probably one of the areas where we've seen a lot of the action post Royal Commission. Dominic, could you give us an update on what some of those key changes are in the industry?
Sure. So I should disclose I'm a former trustee director of an industry superannuation fund, Club Plus Super, and I act for and advise a number of industry superannuation and retail super funds, but I don't speak on their behalf. My views. So, look, superannuation is a $2.7 trillion industry in Australia. It's all about our futures, and it's thus probably one of the most, I might be biased, but the most significant economic sectors. And it will have increasing consequence for many, many people. And thus it is a highly contested area just for that, but in fact, as we know, is highly contested anyway. So the list I have, I've selected for you 3 principal changes. Essentially, as you know, in Australia we have a default system whereby people, the way they often hear about a superannuation fund will join their first super fund is because their employer suggests to them or defaults them into a super fund when they don't actually themselves elect. Or they respond to marketing by banks and they may go into the retail sector. And so what has been happening, the very first amendment is the repeal of the system where the Fair Work Commission would review whether or not particular funds would be listed on particular awards and thus be the default fund for those people who are employed in particular awards. That had basically been suspended for many years and finally has been done away under the existing coalition government. But the measures that have gone through in February and both of them in April this year, just in the final days, I assume, of this Parliament. The election hasn't been called today.
Oh, yeah.
Been busy. So, and they focused on substantial changes to super, both the structure and responsibilities of trustees, and how they engage with employers, and what they need to do to try to preserve the largest possible benefit for people ultimately in their retirement. So some of the things have been to deal with insurance within super, so that people don't have premiums just sort of whittling away and fees whittling away their account balances, dealing with inactive and low balances and trying to consolidate active accounts into one. The big issue that hasn't been dealt with by the Commission because it was outside his remit was whether or not the default fund system should continue. So Commissioner Hayne said in the absence of that occurring, the particular conduct that he wanted to focus on was employers being induced to list a particular fund by reason of some sort of treat being provided. And that has been tightened up in terms of and made into a civil penalty obligation that will be difficult for most funds to meet without substantially changing the way they engage with employers. And the last thing I was going to say is that Hayne recommended that there should be a superannuation consumer advocate. So I saw there was $100,000 in the budget to scope that. And APRA is proposing to look at the sole purpose test. What can trustees do with your money? Does it all have to wait to the end? Or can they use it, for example, to provide financial planning services, bringing out to invest in social impact investments, things that are more near term rather than long term. And that's going to be a highly contested area. So I'm demonstrating how much I'm obsessed by this area.
You're in good company, I think. Yeah. Dimity, I want to pick up on the point you raised around fairness and sort of extending the scope of fairness and other norms that, while I think are familiar to labour lawyers, are not necessarily familiar to certain aspects of the law. Could you expand a bit on the legislative changes that are coming out of these normative recommendations?
Yeah. If I may crave your indulgence, I might just talk for a couple of minutes about what I think fairness means in this context. I already mentioned perhaps one of the central meanings of fairness in a financial markets context, and indeed in any market setting, and that is mutuality of value. And that has been one of the surprising things, I think, that has been shown to be the case across a number of different financial functions or sectors of the financial industry, that the degree to which value of what the customer gives to the provider is not matched by what the product or service that is received by the customer amounts to. And that has obviously been very obvious in fees for no service. It's been obvious in unsuitable product recommendations in financial advice. It's been clear in opaque fees, along the lines also of what Don mentioned in terms of fees and premiums for products that are not required or suitable, such as life insurance perhaps for very young people joining a superannuation fund. So there are a number, and of course the most egregious example over the last while has been credit insurance for people who take payday loans. That is perhaps the most egregious example. So there has been a prevalence of this lack of mutuality. And the thing about financial services is that it is a business built on trust and confidence. And if you're not even getting reciprocal value in the products and services that you're sold, that it's an erosion. A second area where you can think of the way you can think about fairness is fairness in terms of equality of treatment. And one of the things that an equality of treatment might mean actual equality, that's very rare. But equality of opportunity is something that we like to think we pride ourselves in relation to financial sector. For example, fairness of access to financial information from financial reports or disclosures to the stock exchange, fairness in access to market offers and so on. And in pretty much all of those instances, it's fairness of opportunity to participate, which is what is offered, rather than absolute equality of treatment. In some narrow takeover settings, you get close to equality of treatment. And I'm beginning here to talk about fairness in a kind of fair-handedness kind of way. And one of the things that the hearing showed was that if you are a loyal customer, you often don't get the same deals as the new customers get, despite the fact you've been loyal. So that's an example at a more obvious end of where there's not equal treatment and there's beginning to be this segmentation that data analysis allows providers to offer to different segments of the population, a kind of rationing approach in fact. And then finally there's kind of natural justice type fairness, that you listen to the other side, you listen to your customer, especially in a dispute or remediation setting. You try and imagine what it's like to be in your customer's shoes in order to imagine how, as a dispute resolver in a large organisation with standard form contracts and a lot of knowledge and power disparity, how you might treat somebody in that kind of setting fairly. And at the very core of what it means to be fair in any type of situation is that you can understand and work out how to respond to another person's situation, or in a colloquial sense, you stand for a while in somebody else's shoes and you can respond to their situation. So, having said those sorts of things, how are we playing this out in a legal way? Well, Fairness is playing out in a narrower legal way by making, for example, efficient, honest and fair, which as I mentioned is a statutorily inserted licence condition of everybody who holds an Australian financial services or a credit licence, a term of their licence. And up until to date, honesty has been reasonably developed and efficiency has been often talked about. But the judges have tended to say, well, this is a compendious term and we don't need to examine either the meaning of all of these normative values in this triplet, nor do we need to match the facts up too carefully. But we can just say that overall it hasn't been efficient, honest and fair. And Justice Gleeson in the Westpac, ASIC and Westpac case did actually home in on the fairness element a little more than many judges have in the past. Now, up until recently, that requirement to be efficient, honest and fair, if you breached it, not much could happen to you because really no regulator was going to easily take away a licence or even suspend a licence for breach of an efficient, honest and fair condition. But now it's become a civil penalty provision, and if you have insomnia, or if you like to wind the wet towel around your head, or your knee, yes, or me, you can read the schedules to the Treasury Laws Amendment Strengthening Corporate and Financial Sector Penalties Act 2019, which Don has kindly put on this list. And you will see there that in what is a amended section 1317 big E, there is a new list of civil penalty provisions, which is much, much longer than the old one was. And it now includes, as an amendment to section 912A15A of the Courts Act, that's one of my party tricks, the fact that efficient, honest and fair is now a civil penalty provision. So is the requirement to comply with the financial services laws. Now, and those of you who are familiar with section 1317E and its civil penalty consequences will know that the previous legislation, or the now amended legislation, divided civil penalty provisions into corporate and fund civil penalties and financial services civil penalties. And now there is a third category called uncategorised civil penalties. I think the parliamentary drafts people must have run out of inspiration by the time they got to the schedules. In a second. And the thing about the efficient, honest and fair amendment, making it a civil penalty, is that it is an uncategorised civil penalty. And those of you who know about the civil penalties as well will know that in addition to a breach of the underlying substantial provision, which is a civil penalty provision, in order to have a pecuniary penalty order or a disqualification against somebody for breach of a CP provision, it has to be serious or it has had to cause material detriment to the corporation or the fund. But uncategorised civil penalties, of which efficient, honest and fair is one, have no requirement that the conduct be serious and no requirement of causing detriment, or prejudice rather. So this is a quite serious deal, and it means that you can be in line for a civil penalty, a pecuniary penalty order rather, disqualification or a relinquishment order. As for dishonesty, it'll be very interesting to see what is made of what ordinary people think of what's been acceptable to now as fairly standard financial behaviour within the bubble of these large institutions, when it is the opinion of ordinary people which counts. Whoops, we're getting too close now. It's 7 o'clock, we've got to stop. So I'll leave it there and bring you in.
Oh, the only point I was going to make was something Miranda and I have been discussing. It's weird, you're all in the dark. Is that these provisions like 912A and the provision in the SIS Act, the Superannuation Industry Superannuation Act, Section 52, which are the covenants that are incorporated into what a trustee must do, which is essentially to act in the best interests of members and other obligations. They were all initially enacted and subsequently interpreted by courts, not being civil penalty provisions. And ordinarily when something is a civil penalty provision, they have a certain sort of regime of construction or interpretation that is overlaid into that. So there's going to be some interesting and difficult case law and difficult to advise those people who are on the other side acting and defending, and also for the regulators to sort of understand how it's going to apply, because there'll be an element of unscrambling the interpretation and then reapplying the interpretation or gathering what will be the relevant statutory purpose or objective in this new regime. So it makes it an uncertain time for both the institutions and those working for it, and also the regulators who have very high expectations of results soon. Big, fast.
The other thing that I'd say, I think, about that point and how courts are going to interpret the new, I guess, effectiveness of the efficient, honest and fair rule is really how does it relate to existing concepts of unconscionability, how does it relate to the existing provisions about misleading or deceptive conduct, what's the sort of where does it sit on the continuum of the existing norms? And I think that's a really interesting question. I think obviously the other consequence is going to be that, and look, I apologise because I haven't actually sat up late and looked at the schedules, but breach of the civil penalty provision, enables damages claims to be brought as well, and there's never been the ability to bring a damages claim for breach of Section 912A. So I think that is going to be a very interesting ground of contest.
And just on that, it's and that's why I also think it's going to have a knock-on effect, because I think you'll ultimately see more consolidation in the superannuation sector, like more funds will merge because there'll be less directors, there'll be a need to have more directors who are in it full-time or have expertise, because the obligations are so much higher and the exposure is so much greater. It's just a kind of example of things, the ripple effect of identifying misconduct or inadequacy in the system and then it having to play out in a very short period of time.
If I can just double back to the customer interest, which everybody in the room I'm sure is interested in and you have a particular care for. One of the interesting provisions in this schedule, which will now be in Part 9.4b, where all the other civil penalty stuff is that there is a specific section which says that in the judge deciding on orders that may have been applied for, so in other words, given the pot of money that the defendant might have available, in the competition between pecuniary penalty orders and relinquishment orders, which are debts owed to the Commonwealth, and the compensation orders, which a judge can also order, which Miranda has mentioned, it is directed that the judge should prefer the compensation to customers, or it depends whether it will be to customers directly or indirectly, because it will be damage compensation to a corporation, which one assumes then finds its way, or to the fund, which would find its way back to members, etc. So it's interesting that ASIC for decades has prioritised compensation. And one of the things that Hayne did was to say we want to see denunciation and punishment much more. And the legislature's basically come out and said, actually, we would prefer the judge to think about compensation before the judge thinks about really, really big pecuniary penalty orders or very, very large relinquishment orders. And after all, relinquishment orders under this new scheme of things can be worth, just check me here, up to $20 million.
Half a billion.
Half a billion, yes, half a budget.
Small change.
So a lot to a corporation, yeah.
Can I say something about that? Because I know obviously that, ASIC came in for a lot of criticism over its sort of approach that was directed at sort of, obtaining negotiated outcomes with companies. And look, in my experience, certainly compensation is, was always or almost always an element of those enforceable undertakings, but certainly the few that I've had cause to look at very carefully, it seemed to me that the compensation did not really reflect the true extent of either the profits obtained or the loss caused. And, that was because there was, very robust negotiations by wrongdoers with ASIC where they'd agree to pay some compensation, but certainly not all. And so, I think what Justice Hayne or Commissioner Hayne has said very clearly in his report is to refocus on the customer, is to say these sort of community benefit payments that were sometimes made, a donation to the Superannuation Rights Centre or, a
Financial literacy fund.
Exactly. Yeah. We're not really cutting it in terms of meeting the needs and the rights of the community. And so, I don't see the sort of push towards ASIC, litigating and seeking public denunciation as being necessarily incompatible with compensation, although ASIC's ability, obviously, to litigate to obtain compensation for people who've suffered loss is actually quite limited still.
There's still a scale issue. ASIC had been in some respects understaffed, of course, or they had less experienced staff, or they had staff that were on secondment that had come in from entities that they had been regulating and coming in to bring knowledge, but there's also these issues, they don't have them on long-term contracts. And that is changing, and they've now launched a new Office of Enforcement and adopted not a litigate first, but a why not litigate mantra. So we would expect to see substantial launches of enforcement action, one would think. But we shouldn't forget that ASIC also has internal disqualification powers and can do it through its own administrative processes. And one of the things about that is, whilst evidence is given ordinarily for Royal Commissions can't be used against individuals because they've got a privilege against self-incrimination, that's not the case in relation to the licensing function. So internal administrative processes by ASIC and also APRA can be used they can use that evidence to disqualify individuals and also impose new licence conditions or withdraw licence conditions. But APRA has got 100 new staff, a budget for 100 new staff. APRA has, as far as I know, a very limited, you can't say anything about this, very limited enforcement staff, and is looking to expand that, and it has a much broader enforcement remit, but it will have challenging cultural changes to embrace within itself, to move from a regulatory supervisory role and primarily prudential rather than conduct regulation, where all that expertise is currently housed in ASIC or the ACCC, which have, of course, a terrific record of regulatory action. You must pursue a question.
I was just going to, Dimity, I know you're limited in what you can talk about, but you are involved as an expert group assisting APRA on their review of enforcement policy. Is there anything you can provide to us, reports not made public?
Yeah. I think it's no secret that the area in which APRA would be more likely to move to more formal action is superannuation. They will continue to have supervision of the sort that they've done successfully for a long time as their main regulatory mode of operation. And that is absolutely necessary for the kind of work that they do to continue on. I think it is also clear in the public domain now that, and Wayne Byers made it very clear in the witness box by saying it expressly, that people in APRA think that when something goes to formal enforcement, they have failed. And that is a view that they feel right from the supervisory level to the top.
Because they have people in, or they have regular prudential consultations face to face, supervising entities, which historically didn't happen to banks from ASIC's perspective. ASIC wasn't coming in.
No, but we can talk about that part of it in jointly supervised organisations. ASIC is now putting in people to do continuous, close and continuous monitoring, but it's an evolving story as to where that might go. But getting back to APRA, I think Dom's point about cultural change is really central, because if you think you've failed, if you have to pick up the more formal regulatory tools at the enforcement end, then you'll be reluctant to do it as a young supervisor because it might have an impact on your career, and you might be reluctant if you're on an enforcement decision-making body to do the same too, because in a way you might be seen to be validating an approach to a regulated institution which undermines the trust and confidence that you have striven to develop with their senior management and boards. So I think that the action taken in December last year against the directors of IOOF shows that APRA will not continue to be endlessly patient with suasion and quiet ways of doing things, and that they will move more quickly to more formal action than they ever have in the past. It will be necessary for them to train these new 100 people. It will be necessary for them to find these new 100 people. But for those of you who might be interested in seeing what could be ahead, have a look at the Prudential Regulatory Authority in the United Kingdom. They have a great website. They're part of the Bank of England, but they are a self-standing regulatory division of the bank. And they have now been taking formal enforcement much more regularly, much more vigorously, and in a way that they have navigated without losing the impact they have through suasion. It's been a learning curve for them. I think it will be a learning curve for APRA to work out when and against whom and in what way they will transition along the spectrum. But I think that what has been happening at the PRA might not be a bad roadmap for some of the things that APRA will do here. And just to finish this little phrase of conversation, people worry that formal regulatory action by a prudential regulator will open a can of worms of the institution, and that there will be a run on it or whatever. And in the past, the lack of coordination between APRA and ASIC, or the PRA and the Financial Conduct Authority in the United Kingdom, has been because if conduct action is taken of the more denunciation and public sort, then the prudential regulators sitting there going, oh golly, is a relinquishment order of 525 million going to tip this fragile organisation over to something that might punch its way out of trouble, or for whom we could organise an orderly resolution? really we're not sure that this is a good idea. And so the PRA has a power to direct the FCA not to take action on the FCA's conduct mandate if they're trying to sort things out by suasion and orderly resolution behind closed doors.
I'd like to see who wins in a battle between us.
Well, watch this space.
That's the answer to
ASIC has asked for directions in powers in relation to product intervention powers and design and distribution obligations. We haven't seen much movement there. I think there's a bit of work that has to be done before APRA gets a dramatic set of new powers, and the possibilities for coordination and encouragement towards coordination, which ASIC and APRA were urged by Hayne to do, that is like the cultural question of whether to litigate or not, a work in progress as well.
One of the things that this is there's an astonishing sense of deja vu. So any of you who might remember the collapse of H&H Insurance, remember that there was a Royal Commission that came after that. And one of the criticisms that have been made about APRA in that Royal Commission was that it had been too close and too, talking to and not taking any kind of conduct action or enforcement action. And needed to lift its game. And so after the HIH Royal Commission, APRA took a large number of enforcement actions and went about, essentially got a shopping list from the report and went about disqualifying everybody. Until such time as they lost their disqualification power, internal power, and had to go to court to do it, and then stopped. They didn't go to court for another 10 years. So, and now they've changed that with the IOOF action. But I think it's an element of how there's this sort of a generational changes coming through, and I think that will be have to be a watch this space. I think.
So one other point you can make about APRA as well. Wayne Byers has made it very clear. And I think this is reflected in the root causes of the Financial Royal Commission itself, that they're very good at financial risk. And Australian banks are very good at managing financial risk. But he's openly admitted at the hearings and in speeches that APRA is much less good and much less familiar and has tools that are much less well honed to deal with non-financial risk. They've always thought that that was really ASIC's boat. But you only have to look at the condition of A&P to see how non-financial risk can monetize itself through drops in share price, exit of funds under management, remediation payments, and penalties. And so I think that APRA understands better now that they have to look at some sorts of conduct risk and go, okay, it's a conduct risk, it is an ASIC baby, but does it have prudential implications as well? Should we jointly act? And so our two mandates should be coordinated in action together. And I think that's what Hayne was really keen to have. And it's a nut that the PRA and the FCA in the UK have been working for over half a decade now to crack better too. And Andrew Smulo's over here, and he's been doing a lot of work with the South African Twin Peaks regulators. And in South Africa, they have a great chance to do a Mark II of Twin Peaks and have actually begun the process of litigating for overlapping powers between the two regulators to discharge their mandates in a more coordinated way, their separate mandates in a more coordinated way.
I'm mindful of time, and so if the panel will indulge me, we'll push on a little bit and perhaps save a couple of questions from the audience till the end if you have time to stick around. I want to change tack a little bit. You mentioned these risks manifesting in financial risks, for example, with A&P. Has the flood of litigation predicted to follow the Royal Commission eventuated? Miranda?
Well, not yet, but I think There's not a lot really on the books at the moment, but I think in some ways the sort of legislative reforms are, a space to watch definitely in terms of, creating some new avenues, I guess, where, people who've suffered loss can potentially recover it. So, I mean, there were a lot of predictions that there would be a flood of class actions. There's a couple of sort of interesting consumer cases happening at the moment. So my firm filed a class action in February against Westpac in relation to its home lending, the way in which I guess it met its responsible lending obligations in relation to home lending. And ASIC is itself prosecuting Westpac on a sort of a slightly different basis in connection with the use of this household expenditure measure, a statistical measure for sort of determining expenditure and benchmarking it against people in similar situations in similar areas. And so, what the ASIC case and our class action looks at is, was Westpac meeting its obligations under the National Consumer Credit Protection Act to do a proper assessment of unsuitability before it entered into a loan, and also was it breaching the obligation not to enter into a credit contract that was unsuitable. Now, Westpac was using this household expenditure measure in circumstances where it had asked customers to declare what their income was and what their expenditure was, but it wasn't verifying any of that data from the consumer. So it was using this kind of automated system, and it wasn't aligning on the banks in doing that. ASIC's case is really that Westpac should have taken what the consumer said about their income and expenditure and just determined it on the basis of that. Our case actually says they should have actually taken a step to verify, and they should have done a proper assessment rather than just accepting what was given to them. Commissioner Hayne said a little bit about this in his final report, but not very much, because the ASIC case is actually going to trial in a couple of weeks in May, and it sort of had a very interesting road, speed hump really, the ASIC case, in that ASIC and Westpac agreed on a civil penalty of $35 million at the end of last year and brought it to Justice Perham in the Federal Court and said, please, make these orders and declarations of contravention, and please order the civil penalty be paid. And it became quite clear that ASIC and Westpac were completely at odds about what conduct constituted a contravention, and there was really, that was very much glossed over, and the judge said, well, I can't be satisfied that there was a contravention because you can't agree on what was the contravening conduct, and I'm not going to make this. I'm not going to make these orders. You can go away with your proposed $35 million penalty because I can't really work out whether there were 5,000 contraventions or 200 and something thousand contraventions. So how can I possibly determine, what the appropriate penalty is? So that's going to trial shortly, and as I say, our class action is similar, but it sort of goes somewhat further, I guess, than the ASIC application. The other consumer case that has sort of come out of the Royal Commission so far is about junk credit card insurance. So this kind of junk insurance that you get offered when you sign up for a credit card, that it turns out if you're unemployed or a casual worker or a pensioner, you're not actually going to be able to access the benefits of. So they'll sell it to you and you'll pay for it, but you'll never actually be able to claim under it. And so that's a case that Slater and Gordon filed in September last year. And then, of course, there's there's the AMP class action, which is a shareholder class action where 5 firms, including mine, made a speedy dash to the courtroom door. Well, some of them were more speedy than others, I suppose. Ours was, of course, very undertaken in a very careful and deliberate way. Between May and, in a 30-day period between May and June last year. And at the moment, those cases are stalled while the New South Wales Supreme Court figures out what to do with 5 different cases on the same topic. And those cases are really about the, quite incredible drops in share price that happened in early April last year, when AMP disclosed that it had been charging fees for no service, when it became clear that this was not really just an administrative mess up, but in some cases it was known to people within the bank that these fees shouldn't be being charged, and they continued to charge them. And they also lied to ASIC, or misled ASIC about what they were doing about it. So, it will be interesting to see, I guess, what happens to that class action, because it does, I think it probably concerns, you know, among the most egregious conduct that was disclosed during the commission. And following on from, you know, to other egregious conduct, the APRA litigation that Dimity has referred to against IWF, which is where APRA is seeking disqualification orders against the CEO and other executives within APRA for sort of failing to meet their best interests obligations and so forth. A number of firms, including Shine and Quinn Emanuel, have announced that they're bringing a shareholder class action in relation to that conduct as well. So I think we'll probably see some more things happening soon.
So with a more aggressive approach by regulators, is there still a benefit to having private litigation come in behind? What's sort of the interaction between the two?
Yeah, because there can be findings made, findings of contravention, and the constituent elements of those findings can be essentially deemed facts in the subsequent private claims, civil claims, I won't say they're private claims, but claims on behalf of shareholders or beneficiaries. So that streamlines it. Plus there's, if there has been an investigation, or indeed the Royal Commission itself, I mean, the Royal Commission itself is going to form a preliminary discovery at large, so, you know, you just log on and there's all the documents. So that's streamlining that kind of litigation. And also there's an element of, in some sense, the work being done, because if a regulator has determined that there is a proper basis to bring a proceeding and has reached the benchmark that they are confident they'll be able to get a civil penalty contravention out of it, on the balance of probabilities, coming in behind on a civil claim makes that decision making much faster, at least.
Well, look, it may do so, but it's if you're thinking, you know, is there a good basis to seek compensation on behalf of some cohort of consumers, and you know that there's a regulatory prosecution underway, I guess it probably does give you some greater degree of confidence. But having said that, you can never afford to wait around to see what happens with that litigation, you know. And sometimes in fact, private litigation moves faster than regulatory litigation as well.
Well, that won't happen anymore.
Apparently not. But I mean, I think it is important to see the systems as being complementary to some extent. As you know, ASIC and the ACCC have acknowledged that private enforcement and class actions play an important role in obtaining compensation for consumers. The regulators are far more limited in their ability to obtain orders that result in compensation of victims, and so I think we're always going to have this system where both types of enforcement take place. Commissioner Hayne made some sort of interesting comments, I guess, about the sort of social good involved in public litigation by a public body, and the fact that regulators, I guess, have different choices to make and are constrained in ways that private litigants are not constrained. It's, you know, probably easier to settle a case if you're a private litigant. Having said that, if you've ever worked in the field of class actions, it can be very complicated to settle class actions, and there's all sorts of scrutiny involved in that. So, you know, I guess the two systems, I think, should be seen as complementary. And so I think, you know, for example, the Westpac and ASIC and the Westpac home loans class action that I've just talked about, I think is a good example. Westpac's obviously seeking a very substantial civil penalty, but it's not in a position to seek compensation for the consumers who, you know, potentially entered into loans that weren't suitable for them and suffered loss as a consequence. So I think it's very good that we have, you know, both systems, really. I think they're absolutely critically important.
We've covered a lot. I want to give the audience the opportunity to ask a couple of questions. Does anyone have a burning question coming out of today's discussion?
I want to go back to the staffing point, particularly in relation to APRA, which...
So do you want to state your name?
Sorry. So my name's Sarah, and I'm a lawyer at Ashurst, and I worked briefly on the Royal Commission for one of the major banks, and the thing that struck me was there just aren't enough financial regulatory lawyers in the country to staff the Royal Commission. So we were pulling people from overseas offices and interstate offices and people who don't typically work in that area to just all kind of pitch in. now that it's all over, we've kind of gone back to our respective fields, but where are we going to find 100 people to staff APRA?
I think it's a good point for this reason. I mean, you would have got the sense from some of the things that have been said that financial services regulatory law is complex.
Yeah.
It's voluminous. Understanding the economic consequences of it as well is also very difficult, and it's not taught at university. Except with Dimity. But in the sense that it's not, there's a layer of it that is taught, but there's not a body of people who have come through, and what we're sort of merging into is a big leap forward in a short period of time. And so what you're seeing too within ASIC is they have had to move people into banks as part of the supervisory measures, which is the new step, and then they've had to hire people in to come in and replace those people within ASIC, and they've been taking people from the bar on short-term contracts and solicitors. So that's all having to happen. Within APRA, we've already talked about it. I mean, it's the great new world for those who want to do the law, who want to do this sort of area, but there is an element of needing to fast track quickly and people. And there's an element of, as what Dimity was saying, I mean, the senior managers regime that went in the UK has been largely replicated in the new BEAR regime in Australia. So there is, as you were saying, overseas people who can come in, but that's why we do things like this, spread the love for financial services.
Can I also just make one other comment, Sarah? Hello. Financial services regulation is complex, but it shares a lot of the same features as other regulatory regimes. It uses disclosure, it uses licensing, it has a mixture of regulators, sanctions and criminal prosecution powers. It has an inspection and audit capacity, such as seen in APRA and in continuing and close monitoring. So if you have been in food labelling or some other kind of area, pharmaceuticals for example, you will understand about disclosure. And the way I teach my students financial regulation is to say, I'm trying to kick you out to go and work in the regulatory state wherever you may find it deployed as a technique of governance. So I think that people can transfer if they're willing to be staying up at night and with the wet towel around their head a bit with the learning curve.
And you're right about the similarities because, for example, the Aged Care Royal Commission is now investigating the regulatory structures that sit around the provision of home care and residential aged care services, and they have increasingly well-funded regulators. There's a new regulatory commission that's been set up, and there's quite complicated reporting and licensing regimes because we think it's important, and people and it's in a similar way to financial services is aged care. There are a large preponderance of people who are either going to be in a situation where they are more easily exploited, or they have less information, or they're less able to move as fast as this well-resourced provider, be it a bank or be it an aged care chain and so on. So they do have an element of being consumer protection regimes. It just happens to be that it's financial services, or it just happens to be aged care or provision of education, like in the vet system.
I might just get another question. Elijah, you had your hand up.
Yeah, my name's Elijah. I'm among other things, I'm a banking finance lawyer at Wilcox, where I'm also a researcher in tech. And I wanted to ask the panel about this question about, and it kind of connects to the first question from the audience about the economics of enforcement. What plans are afoot for the use of regulatory technology to deal with the resource constraint that ASIC and APRA and other groups are faced with, and to deal with the complexity challenge that comes with so many moving parts and so many people to monitor what's going on?
Right.
Well,
starting from the regulatory side, I think the answer is fragmented and developing. ASIC is beginning to use regulatory technology much more, but it's very particular skills to develop it. You can't just import it from the SEC because we have different rules and different standards and different approaches here. So you have to customise it. And then you have to pilot it, and then you have to deploy it. So a very good and long-standing example of RegTech in Australia is Signal G from the Stock Exchange. They get all the data of all the transactions done on the ASX, and there's a big data analysis place where this feed goes in and it can pinpoint transactions which appear to be anomalous, and then like Turnitin plagiarism, technology with student essays, you don't immediately, expel them or suspend them or whatever. You put on notice with a red flag, and you go in and you send people to investigate, and it might be insider trading or it might not be. But there's a long way to go. There's definitely a long way to go. On the provider side, I think, and I don't know much, that the banks are at different places with this. I think all of them are hoping eventually to get real-time supervision of intermediaries, for example, who give advice, or mortgage brokers, so that they don't have to wait until a field audit to be done that might be 3 or 4 years later.
Which I can talk about a provider that's got that.
Yeah.
So but one of my clients in the Banking Royal Commission was Aussie Home Loans, which is a subsidiary mortgage broker of CBA, and it had introduced a RegTech solution to its compliance problems of having a broker accountability requirements. It had put in a new broker dashboard, and so they had all this reporting. So rather than going out and doing, actual physical file audits, they had, getting to a point of being able to have real-time data of how many written today and what were the factors they took into account. Did they apply HEM and across how many? And then being able to assess, for example, are there any outliers? Is there, one particular broker in one particular place suddenly writing 10 loans to one family? No, those indicators, and so that's happening. And the other aspect is that ASIC has been running a regulatory sandbox, fintech sandbox, for some time, where new providers that want to provide financial technology and regulatory technology, which would otherwise require to be licensed. Like if you provide robo-advice, you have to have a license to provide general or personal advice to a consumer. They can go into this sandbox and try and work it out, and maybe run beta programs and have trial runs with consumers without being in breach of the law, and sort of learn by doing. Now that hasn't been tremendously successful in Australia yet, and there's a range of reasons why that is the case. And one of them is this difficulty of there's an element of having to be homegrown because it's got to respond to the Australian regulatory system. You can't sort of buy it in Israel or buy it in the US and wrap it in. But there's elements of that happening.
But circling back to the fairness question, one of the things that we're going to have to crack when we, for example, have robo-advice as the advice access solution to the cost of personal advice, is whether the settings of the underlying software are fair to the consumer. We already know that robotic services delivered in other settings and AI type solutions have, unless you're very careful, the capacity to learn about the context that they're dealing with and to move, because of the regularity in which particular fact situations come up, to discriminatory decisions within the algorithms of the service supplying systems. So if you think that personal financial advice remediation is expensive when it's all been done with a human being or on the phone or whatever in a file. The degree to which unfair assumptions could be built into algorithmic advice would make it look like a walk in the park, because the whole point of that is to exponentially cover the very large uncovered market in Australia of people who don't get personal advice, and to do it in a way that's automated. Oops, that's my phone. So sorry. And that is something we have to be very, very careful of. And honesty and fairness, transparency are going to be really, really important. They only said it 3 times.
I might take one more question from the audience, and in the meantime, I'll ask the panelists if they have any final thoughts to think about those. I think.
Thank you very much. Thank you for this fantastic talk. My name is Andy Schmuller. I teach at Wollongong University, and I've been advising the South African government on the adoption of the Australian regulatory model. Hiring, of course, is withering for the last 2 years. And I've had great success. I go in and I talk to the regulators and I tell them horror stories about what's happened in Australia. And I watch their faces and I wait until I get to the point that they start looking at each other furtively like, is he lying? Is he making this up? Is he a nutter? And then I put something up on the overhead projector from the Sydney Morning Herald, and I watch the change in their faces from that furtive to just the blank, relaxed. And I've said to them, if you don't land a whale and crucify it upside down and stick it outside your front door in the first week of your operation, they will laugh at you. And I think they're learning. They're certainly cracking the whip in South Africa. So I want to ask a question. I've got so many hobby horses. I've got a whole polo team of them, but I'll limit myself to one. I want to ask you this. I think Hayne got it wrong when he said that complexity comes from carve-outs. I think he misunderstands the nature of financial regulation. As one author put it, there is no industry that innovates as quickly as financial regulation, which is why you cannot keep up with the financial industry if you use prescriptive rules-based regulation. As one author put it, these rats are agile. As another author put it, if you take the approach of prescriptive regulation, regulators are always stuck fighting the last war. So we have ostensibly adhered to a principles-based regulatory regime, ostensibly because we've done so in just about 1 or 2 sections of the entire expanse of the Corporations Act. Section 912 is a principles-based section, one lone outlier amongst thousands.
I'm going to bring you to the questions then.
All right. I don't think the judiciary understands a principles-based regulatory regime. I don't think the profession understands it. I don't think ASIC understands it. I don't think they understand that they need to argue definitions as terms of art, not legal definitions. And I think until the profession and ASIC is sensitised to it, and until they start to educate the bench, we're just going to be chasing our tails for another decade.
So I think that was, although you more eloquently put it, the point I was trying to make about how will 912A be interpreted by the courts. Now that it is up front and centre, is it going to completely change the way in which we are regulated, or all these parties are regulated and the regulator acts? Or is it going to descend into a legalistic, it's a civil penalty, therefore what does this bit mean, what does this bit mean, what does this bit mean, what does it mean as a group? Just the way that you were sort of alluding to Justice Gleeson trying to sort of go down that path. So I think there's a big change. It will be the same when the best interest test for superannuation trustees comes up, because it too is a principle of acting in best interest, but it's never been locked down as to mean, is it really a process test, is it an outcome test? Maybe we'll know it when we see it. I think that we're coming up to that sharp point, and something, maybe what you say is right, that we're just doomed to keep repeating what Australian Australian systems have done with like HAH in a period of time. This one, period next.
So I am getting very mindful of the time, so we might finish it there. Maybe give you 20 seconds each if you've got sort of any final thoughts on the state of financial regulation enforcement.
I do. I would say there is one recommendation that Commissioner Hayne was never going to make because it's outside the remit. But I think what we need whistleblower reform. This Royal Commission only came about because there were whistleblowers within financial institutions who were brave, who came forward and who spoke up. Now, in America, the SEC has a system where if you're a whistleblower and you come forward and they take action and prosecute a company, and you will get 10 to 30% of the penalty that they impose on that company. So there is a bounty provision which incentivises them to come forward. There is nothing to incentivise whistleblowers in this country. There is nothing but difficulty that results from that. So I think we should recognise the courage of those people who caused this commission to happen, and ultimately we need some broader reform to protect people who are brave enough to do that in all of our interests.
In the customer area, I think we are moving in financial services away from disclosure and the idea of the rational actor model and caveat emptor across to a model of regulation which we are familiar with, much more familiar with in health, in airline safety, in product safety, and it is a safety first mandate. And it recognises, and I agree with Miranda, that one of the great gaping gaps in the Hayne report was any analysis of the nature and conduct and capacities of customers. It just wasn't there anywhere. And now I think we're beginning to understand legislatively and in the judicial area that we have to move away from caveat emptor to product design and distribution that targets markets of customers in a mass market setting appropriately. It can't be on a one-to-one basis because the market is too large. It has to be at scale. That's one of the ways you can do fairness at scale. And so I think we are moving towards caveat vendor or seller aware. It's going to take a long time, and it has to be accompanied by a change of understanding in provider organisations about what that means and how you in future must approach your connections with your customers. But at the centre of it all, I go back to it again, is this idea of fairness and being able to stand in the shoes of the customer and say, what do they need? Not what do they want or what do we want to sell them, but what do they need? Because that will not only result in greater customer benefit, but it will also result in a well-functioning financial system.
So my last point is for the lawyers in the room. So we heard a lot about ethics as part of banker ethics and during the reports of the Royal Commission. But I think we need to be reminding ourselves that we have an obligation as officers of the court and as owing a duty to act in the best interest of our clients. That sometimes that means we don't, well, always that will mean we have to give frank and fearless advice, and it might be some kind of advice that our clients don't like, but it has to be done. That's a challenge for us all.
Thank you. Yes, if you'd all put your hands together for hosting us, and thank you for joining us this evening.